SJC-10877 Commonwealth versus Britt.
May it please the court, my name is Joe Hanafi. I represent the appellant Tonika Britt in the first-degree murder of Jesse Calhoun, the first-degree murder of Robert Turner, and the attempted murder of Antoine Phillips on August 2nd of 2008. I would like to begin with a recitation of some facts that are not in dispute, but bear heavily on my arguments that I would like to pursue this morning. First, it's not disputed that Britt had the gun, the 9mm gun, with her when she went to Hodge's house the first time. She did not go there to get a gun. She had it. So that is no evidence of a plan for that evening. She had had it for months, according to the testimony, for protection.
Protection from whom?
Calhoun?
A dangerous neighborhood. There was testimony with respect to that.
I thought the argument was that she was protecting herself from Calhoun.
No, that was not admitted, and it was not argued. But there was testimony that she had it for protection. The second fact not in dispute is that at 1:30 in the morning that night, Calhoun took Turner and Phillips home from Packy's bar around 1:30. Took them home back to Phillips' apartment where he lived with his girlfriend. Turner was a guest that evening in their house. For the evening, a short time later, 15 or 20 minutes later, Phillips gets a call from Calhoun and tells him, "I'm coming to get you, bring the gun." Now, we also have undisputed evidence that all the cell phones of the individuals on William Street that night, they had the cell phones of Britt, Bowling, Calhoun, Turner, Phillips, and their associates. There was absolutely no evidence of any contact between Britt and Calhoun or their associates during that narrow 15 or 20-minute window. Nor were there any text messages. No cell phone calls, no text messages. And those phone records were intensively investigated. Not only that, but there was no contact earlier in the evening or that whole evening whatsoever. Everybody goes home at 1:30 as the bars are closing, as was Britt and her boyfriend at the time, Bowling, as did Phillips and Turner as Calhoun drove them home for the evening. So this is evidence of a spontaneous and unilateral decision by Calhoun to say, enough is enough, I'm going to get, and there was testimony that he told Phillips over the phone, "I'm going to go get my money from that fat bitch." That's fair evidence. But what I argue in my brief is that the introduction or the allowance of a grossly leading question, given those facts and the circumstances of a case involving self-defense and excessive force in self-defense, that which was objected to on two grounds, that it was grossly leading, and two, that there was no basis for it. So I submit that that was preserved for review.
But wait, you just, I'm sorry, I'm a little confused. You just said of fair evidence, I'm going to get my money from that fat bitch. That's okay, but so what isn't okay?
The use of the hearsay statement, where is he going to, where were you going, where did Calhoun say he was going to get his money? Where did he say he was going to meet Britt to get his money?
Meet is the word.
To meet. Meet is the key word here, because meet, under a common definition of meet, it means to keep an appointment, or to have, as in terms of where two married folks say, where did you meet? It's like both people are meeting without knowledge of the other meeting. Those are the common definitions of meet.
Well, but isn't it also common to say, you tell a friend, gee, guess who I met today walking down the street? I bumped into somebody I hadn't seen in 20 years. I mean, you use the word meet and met is used in a lot of different ways.
Well, yes, but two things. One, that looks to the past, which the Rule 803 doesn't really permit. But what is going on here is that when the question was objected to, counsel asked for a sidebar, which was denied him. There was no limiting instruction given to the jury as to how they should consider their own definition or their own application of the word meet. So they were left to decide that Britt agreed to meet Calhoun.
Well, that's another step. But let me ask you this first before we get there.
Yes, sure.
I'm going to meet. Is the objection, does it boil down to the fact that it was leading? Because I don't know why it wouldn't come in under 803 if I've got.
Well, if I may, thank you, Your Honor. What I submit is that 803 B3 sub 2 should have been the authority to exclude that statement, in addition to the fact that it was leading and without foundation, because that's the second sentence says that statements of memory or belief to prove a fact remembered or believed does not fall within the exception that 803 permits. The reason for that is that, as the case law says, that a statement that looks backward.
But this isn't looking backward.
Well, I submit that it is for a couple of reasons. One, there was a stipulation at the beginning of trial to the jury by Britt and Bowling that they did not dispute that Britt, Bowling, Calhoun, Turner, and Phillips were present on William Street at that moment. In other words, that was unnecessary evidence that was highly prejudicial. This was not evidence that was needed to prove the presence of Britt or Calhoun or Turner or Phillips. It was, and I submit, used by the prosecutor because of the facts I recited at the beginning of my argument, that he knew that he had to establish premeditation because this was a case of self-defense. To tell the jury that Calhoun said, "I'm going to meet Britt," implies that Britt agreed to meet him. There's an inference of that. And the common law, the common usage of meet was open to the jury to make whatever use of that word meet that they wanted to make. And I would submit that because of the fact that it was unnecessary, hearsay or exceptions to hearsay become important because in the quest for the search for truth.
But everything that you're trying to avoid by making that argument bears out in an entirely different way. she borrowed a car, that VW car, from a friend because it was a car that apparently Calhoun didn't recognize, and she wanted to be in a car that he didn't recognize. Right. Then she parks the car on her street. I'm not even going to get into the parking lot issue. She gets into the parking space issue, but she parks the car on the street. They're sitting in that car for approximately a minute. And then when
seconds, I believe.
Whatever. And then Calhoun shows up. She gets out of the car. She gets out of the car to meet him, and instead of sitting in the car and laying low, so I mean the confrontation happens. It essentially, and she's the first one to appear. Of the two of them, in a way, she gets out of the car and she goes up to him. So what difference does it make what the word meet means?
If I may,
yeah.
One, Bowling is on the other side of a nearby car. They did actually approach fairly in close proximity. But, and this is important, Britt parked where she believed she was able or should be able to park. I'll get to the parking space in a minute, but she wasn't, and this was what I submit in the findings of the motion judge were plain error, and that was he introduced the notion that she crossed the street to meet Calhoun. She crossed the street to go to her apartment. The only avenue to go into her apartment was through the parking lot driveway that met Williams Street. That happens to be where Calhoun parked, and she was embarking to go to her door.
Well, you say that, I mean, this is all inference, correct?
Well, I think it's no. If I may, Bowling said that that's what they were doing, and I'll get to more about what Bowling said in a minute. But
that's the defense. I mean, so there are two different sides to this story, and both properly presented, and the jury happened to believe somebody else's side than yours.
Well, what I'm saying, Your Honor, that it wasn't properly presented because the defense put on self-defense and using the adjutant evidence along with other prior history of the parties, but the fact that, I mean, the fact that Britt lived there and was going to her apartment door does not mean that she was passing by Calhoun to meet with him.
But doesn't the picture from the security camera show her walking across the street directly towards the car where Calhoun was sitting, a car that she had apparently seen just minutes before with him in it?
Yes. But that is the direct line to her apartment. She has a right to go home.
But if she's afraid of him, why would she go home that way?
Because
why wouldn't she sit in the car and wait, or why wouldn't she just bolt? Yeah.
If I may, one, she felt Bowling indicated that there was no hiding from Calhoun at that point. Number one. Number two, Britt's uncle was in the apartment. She tried to call him from the car. He didn't answer, so they say, well, and then Britt says to Bowling, well, let's just go in. So there's as much evidence, if not more evidence, that she was going to her apartment as there is that she was going to meet Calhoun.
But why isn't this just a question of fact for the jury?
Because because of the facts I recited at the beginning, there is evidence that this was that the use of the hearsay spoke to premeditation that did not otherwise exist. In other words, I submit that her walking across the street is no evidence of intent to murder. In other words,
she gets across the street. She engages Mr. Calhoun. Mr. Bowling comes up, shoots, kills Calhoun. She pulls out her gun. She kills Turner. Can't the jury infer that that these were premeditated acts. They both were armed. They were prepared for a confrontation, and they blew two people away.
Well,
like
that's
what
the Commonwealth would have you believe. But
isn't that what the evidence supports?
Well, no, I submit not, because everything that at once, as you just described it, at once it has within that same arena the fact that she parked there for innocent reasons. She crossed the street for innocent reasons. She tried to get past Calhoun for innocent reasons, to go to her house for innocent reasons. And you'll notice that the first picture of the surveillance picture that appears in my record appendix after Britt is seen on the street as she's about to walk towards Calhoun's car shows the three individuals hovering, circling Britt behind Calhoun's car. These were three big, strong men who had gathered.
Wait, I thought that Calhoun and Turner were on the driver's side of the car.
Yes. But as she passed them, one got out one side, the other one got out the other side, and then Phillips, who was in the back seat, got out one. So they're surrounding her. And
so that's the issue of self-defense.
Yes.
And that was argued to the jury.
Yes. But what I submit is the use of the term meat was prejudicial error, because that implies premeditation. The reason I began this argument with the facts that I did was because that's evidence that there was no planned meeting, and the jury never really heard any of that. What they got was they were permitted to use the word to meet to further the argument for premeditation.
Could we go back, though? You said 803 doesn't apply, and you said a statement of memory or belief, right? Isn't that what you said? Doesn't.
Right, the second sentence, statements of memory or belief.
Why isn't this a statement of intention?
I'm sorry?
Why is not this a statement of intention?
Well, first, because this is an exception to the hearsay rule. The hearsay, and why I submit that deceased Declan hearsay is the beginning of this analysis. First of all, there was no issue about intent. There was no issue about, excuse me, there was no issue about, I'm drawing a blank, and just if you can just bear with me. There was the question of
that they were all there.
That they were all there, thank you, was never in dispute. And to use an exception to the hearsay rule, which is really a hidden agenda to bring in evidence of premeditation, is what I regard as highly unfair, because that's not what hearsay is supposed to be used for, or exceptions to hearsay. And again, that's why I began my argument with the important facts that there is as much evidence, if not more, that this was not a planned meeting, and that using the exception to the hearsay rule at a time when it was most important that it not be going into evidence, because one, you didn't need the evidence to prove that everybody was there, because that was stipulated to. Secondly, that exception was used to interject the word "to meet" into the deliberations that allowed the jury to consider that as evidence of premeditation, which is what the Commonwealth wanted, and which is what should have been excluded on the basis of Rule 803. Now, if I may, I want to spend a minute on the question of the parking space. In my motion for a new trial, I argued that the space, the curb was painted yellow. I cite that the Massachusetts Turnpike Authority is clear that a yellow curbstone means no parking. The University of Massachusetts has regulations that say Massachusetts law says you can't park in a space that has yellow curbstone.
You didn't do this at trial, right?
I'm sorry?
This wasn't an issue that you argued or presented at trial.
He tried to, the defense counsel tried to argue it, but I submit he didn't do the job that he was supposed to do. The trial judge dismissed the argument that I'm raising by saying that he effectively argued that it was not allowed to park there, but he didn't produce any evidence that demonstrated that you couldn't park there because it obstructed the people leaving the parking lot reserved for tenants to turn right on the one-way street. The investigation that I undertook for the motion clearly shows the photographs. You try to turn right on the one-way street, you can't do it. It obstructs. Parking in that space was not permitted because it obstructs the exit of cars leaving the parking lot from being able to get by. So that, I submit, should have been, I think it was ineffective for not doing that. The fact that there was no parking sticker on the car to park in the parking lot, the Commonwealth used that argument, and also, and the defense counsel should have introduced evidence that you couldn't park there. That was all in the motion for a new trial. I submit that the trial judge was clearly wrong in his analysis of what it is I'm trying to express here this morning. But Mr.
Hannafy, your time is up.
Thank you, and I rest on my brief.
Thank you.
Good morning, Your Honors. May it please the Court, Teresa Anderson on behalf of the Commonwealth. With me this morning, the trial prosecutors, Assistant District Attorney David Fredette and Julie Higgins. We're asking the Court to affirm the defendant's 2 convictions for first-degree murder, as well as the conviction for armed assault with intent to murder and possession of a firearm. With respect to the defendant's conviction for first-degree murder based on deliberate premeditation of Jesse Calhoun, Judge Gaziano properly instructed the jury, using the Zanetti language with joint venture, as to what the jury needed to find in order to convict the defendant of the deliberate premeditated murder of Jesse Calhoun. My brother raises the argument, and citing back to the Bowling case, where this court held that knowledge of a firearm is a requirement where a specific instruction on knowledge of a firearm is a required instruction where being armed is an element of the offense. Here, for first-degree murder, being armed is not an element of the offense, and the Commonwealth need not prove that knowledge, that where the Zanetti language, that knowing participation with the shared requisite intent is sufficient. Likewise, there was no error in the second instruction regarding excessive force and self-defense. As this court held in Bowling, after reviewing that instruction, both specifically where Bowling had raised the issue and then under 33E also, there was no error in that instruction. And finally, the motion judge properly denied the defendant's motion for new trial.
Well, could you address the issue of the this use of the statement, "I'm going to meet"? I mean, is it your position that it's a statement of intention, not too far from the time, comes in?
Correct. Under Commonwealth versus Ortiz, it's a statement of present intent. This court found in Bowling the prosecutor's questions were based on the evidence. The leading question was within the judge's discretion.
But how did the Commonwealth use it also as a statement of the intent of Calhoun? No, I'm sorry, the intent of Britt.
It could have been taken that way.
So how is it a statement of? how is it permissibly a statement of her present intent?
To the extent it is, it's a statement of party opponents, the defendant's own intent. But here it goes to Calhoun's statement. It's Calhoun's statement, I'm going to meet her on William Street, in the testimony, answering yes to the leading questions. And it's not.
But was it used by the prosecutor to show Britt's present intent?
Did he argue that?
I don't think he argued it specifically. Certainly he argued there was a planned meeting, and there's evidence in addition to this statement that there was a planned meeting on William Street that night.
But what's the other evidence?
The additional evidence would be where the defendants carried loaded firearms to the scene, the defendants parked across the street in an easy access getaway space, where they waited in the car for 43 seconds, and my brother takes issue with some of the deliberate premeditation evidence. Even if you start the clock for deliberate premeditation right at that moment, deliberate premeditation can be a matter of seconds. There's no requirement that a meeting be arranged in order to have deliberate premeditated murder. Here you have 43 seconds waiting in the car. The victims pull up and park across the street. The defendant here, Ms. Britt, approaches Calhoun, and then within 8 seconds, 14 shots are fired by these two defendants. And 3 people are shot, 2 people are killed. And therefore, this evidence of a meeting is certainly more than just this hearsay statement, which is hearsay, but an exception to the hearsay rule, which is proper evidence for the jury to consider, and to consider the word meet either as a unilateral proposition, I am going to meet her on this street, as in I intend to go there, or we have arranged to both arrive at the same time, which is what happened in this case. They arrive within 8 seconds, I believe, of each other, or 2 or 3 frames of the photographs. And if the court would have no further questions, I would rest on my brief and ask the court to affirm the defendant's convictions for the first-degree murders of Jesse Calhoun and Robert Turner, and deny any and all relief under Section 33E.
Thank you.
Thank you.